Good day everyone, my name is Hanghui and on behalf of Group 3. Our presentation today addresses whatever Malaysian's abolition of mandatory death penalty in 2023 was a sound decision. We believe that this change was constitutionally and legally and empirically and justified. Prior to 2023, Malaysians long met the death penalty option conviction for the sentence offense under the Dangerous Drugs Act 1952, the Firearms Act 1971, and the provision of penal code. For example, leaving judge with no sentencing direction whatsoever upon conviction. This was automatic regardless of the offender's background or individual subsistence. This reform came in 3 stages. First, in July 2018, the government introduced a moratorium on execution, effective halting or pending execution. Second, on 10 June 2022, the cabinet formally decided to abolish the mandatory death penalty and restore judicial direction. Third, on 4 July 2023, the Abolition of Mandatory Death Penalty Act 2023, Act 846, came into force, removing the mandatory requirement for 12 categories of offences and introduced judicial direction to impose either the death penalty or a term of 30 to 40 years imprisonment with whipping. At the time of the reform, there are 1,300 individuals who remained on this road entitled to review. So our presentation will demonstrate across 4 arguments that this reform was constitutionally necessary under Articles 5 and 7 of the Federal Constitution, supported by human rights norms and empirical evidence and deterrence counter-argument, and the foundation for a meaningful citizen reform going forward. In conclusion, our group believes that the abolition of the mandatory death penalty was the right decision. It was indeed correction that restored judicial directions, strengthens the rights to life under Article 5, and give full effect to balance of principles in the Federal Constitution of Malaysia.
In 2023, Malaysia enacted the Abolition of Mandatory Death Penalty, which is the Act 2023-80046, replacing automatic death sentences with judicial discretion to impose either the death penalty or a term of 30 to 40 years imprisonment with whipping. One constitutional concern surrounding mandatory sentencing is its conflict with Article 71 of the Federal Constitution, which prohibits imposing a greater punishment than what the law prescribed at the time of the offence was committed. In such a regime, where sentencing laws change between the time of the offence and the trial, judges had no power to avoid applying the harsher sentence retroactively. In turn, directly undermines the principle of legality that Article 7.1 exists to protect. The importance of these principles can be seen in the case of Public Prosecutor V. Mohammed Ismail, where Edgar Joseph J.R.J. held that a parliamentary amendment imposing mandatory death could not be applied to an offence already committed before it came into force, as doing so would violate Article 7.1. The court retained its discretion and imposed life imprisonment instead. The mandatory death penalty created precisely this constitutional tension, demonstrating that even more before 2023 reform, the judiciary had already recognized that removing sentencing discretion entirely made proportionate, individualized punishment impossible. Act 846 therefore did not introduce a new principle. It restored the one Article 7.1 had always demanded. A further constitutional concern is the separation of the powers. While the legislature creates laws, the judiciary determines appropriate punishment in individual cases. Mandatory sentencing removes these discretions by requiring judges to impose the death penalty regardless of circumstances. This undermines the judiciary's core constitutional function. As held in landmark case of Roving Joti Kodeswaran V Lembaga Pencegahan Jenayah or ORS, legislative attempts to preclude judicial scrutiny undermine the basic structure of the Constitution and the separation of powers. While the case concerned outer clause, the underlying principle applies equally here. There is legislation that strips judges of discretion to mere automatic imposition. The abolition therefore restores the proper balance between legislative authority and judicial decision-making, allowing courts to exercise their core constitutional role and carefully considering the unique fact of each case. The reform can also be understood through Article 5 of the Federal Constitution, which protects the right to life and personal liberty. Mandatory death sentences impose the most severe punishment without allowing judges to consider mitigating factors such as the offender's role in the offense or individual circumstances. This rigid approach raises concern about proportionality and fairness within the constitutional framework, especially with irreversible outcomes at hand. By restoring judicial discretion, 846 gives effect to the constitutional principle that punishment must be proportionate to individual culpability, consistent with the protection of fundamental rights under Article 5. In conclusion, the 2023 abolition of the mandatory death penalty was a crucial constitutional correction. It resolves the tension between mandatory sentencing and Article 7.1's prohibition on retrospective punishment, restores the separation of powers by returning sentencing discretion to the judiciary, and gives full effort to Article 5 protection of the right to the life. By enacting Act 846, Malaysia has no weakened its legal system. It has strengthened its commitment to the supreme law of the land, the federal constitutions.
Good day everyone, my name is Hazri and I'll talk about why abolition of mandatory death sentencing was sound on human rights and empirical evidence. The 2023 abolition of mandatory death penalty represents a landmark shift in Malaysia's legal landscape. By enacting the Abolition of Mandatory Death Penalty Act 2023, Malaysia moved away from a rigid one-size-fits-all approach towards a system grounded in human rights and judicial discretion. At the heart of this reform is the right to life. Article 5 of the Federal Constitution enshrines this protection. While Malaysia has not ratified the ICCPR, Article 6 of the Covenant and Article 3 of the UDHR reflect the same principle as persuasive international standards, that the state must exercise the utmost caution before permanently extinguishing a human life. Under mandatory death, judges acted as little more than rubber stamps. For drug trafficking under Section 39B of the Dangerous Drug Act 1952, no discretion existed whatsoever. Abolition restores the ability to consider mitigating factor. The drug mule, under the coercion, or the offender with mental ability, or the minor role in a larger syndicate. People who are morally distinct from the kingpin yet previously received the same irreversible sentence. No legal system is infallible. When execution is carried out, it is final. An innocent person wrongly imprisoned can be released, but an innocent person wrongly executed cannot be brought back. Internationally, the evidence against mandatory death is clear. The UN Secretary General's 2007 report to the General Assembly found that no conclusive evidence that the death penalty deters crime more effectively than other punishments. Despite decades of mandatory death sentences for drug offences in Malaysia, the illicit drug trade did not collapse. Enforcement data shows drug-related arrests continued to rise throughout this period. Globally, by the end of 2022, Amnesty International recorded 112 countries as fully abolitionist in law, with 55 abolitionists further in practice. Malaysia's 2023 reform places it within this trajectory, and its impact are already visible. From over 1,300 people on death row in recent years, that figure has fallen to 140 by end of 2024 following the resentencing processes. The abolition was sound because it replaced a rigid, irreversible mechanism with one that values proportionality, human dignity, and the rule of law.
Good day everyone. To supplement a deeper dive, I, Gabriella, will address the four main arguments raised in defense of retaining the mandatory death penalty, and to demonstrate why, careful legal and empirical examination, none of them withstand scrutiny. The first and most common argument for retention is deterrence. The logic runs that the certainty of death sends an unambiguous message: commit a capital offense and you will die, and that this certainty is precisely what makes it effective. This argument sounds compelling. The evidence, however, does not support it. The overwhelming consensus in criminological research, documented comprehensively in The Question of Deterrence by Roger Hood and Carolyn Hoyle, is that the death penalty itself cannot be proven to be a reliable causal link to reduce crime rates. Michael L. Redolent and Tracy L. Lecoq, writing in Do Executions Lower Homicide Rates? The views of leading criminologists, went further given their survey of leading American criminologists, finding 88% reject the death penalty as a deterrent, with 94% citing insufficient empirical evidence. Closer to home, Malaysia's own official data is telling. According to statistics published by the Narcotics Crime Investigation Department of the Royal Malaysia Police, the very agency responsible for enforcing Malaysia's drug laws, drugs-related arrests continue to rise even as the mandatory death penalty remained fully enforced, increasing from over 72,000 arrests in 2016 to over 82,000 in 2017. The mandatory death sentence was operative throughout this period. If the threat of death was truly deterring criminal behavior, we would expect the opposite trend. The deterrence argument also rests on a flawed assumption about criminal psychology, that offenders engage in careful, rational cost-benefit analysis. Most serious drug offenders act under conditions of poverty or desperation or coercion. The rational actor that deterrence theory requires simply does not exist in most capital cases. Deterrence, therefore, is not a justification for mandatory death, it is an unproven assumption. The second argument invokes Singapore, a jurisdiction that maintained a mandatory death for drug trafficking for decades and has one of the lowest drug crime rates in the world. Why should Malaysia not follow the same model? The most decisive answer is this: basically, Singapore itself did not. In fact, Singapore itself moved away from it. In October 2012, Singapore amended its drug laws to give judges discretion in sentencing, meaning death was no longer the automatic outcome for drug trafficking. The very country used to justify mandatory death found it necessary to introduce the same kind of case-by-case judicial judgment that Malaysia has now adopted in Acts 846. If Singapore's own lawmakers concluded that mandatory death was too rigid, the argument that Malaysia should follow Singapore's original model collapsed on itself. The comparison also ignores the profound demographic or geographic and even socio-economic differences between a city-state like that has 5 million and a diverse nation of 33 million. Singapore's low crime rate reflects on a complex combination of factors: highly effective law enforcement, strong social safety nets, low inequality, high literacy, and a distinct cultural and demographic condition, entirely separate from the presence or absence of mandatory death. To isolate the death penalty as the decisive variable ignores everything else. What works in one context simply cannot be translated into another. The third argument is one of formal equality. The claim goes, if every person convicted of the same offense receives the same sentences, then the law treats everyone the same, and that alternatively, judicial discretion, as the argument goes, opens the door to bias. This is a valid concern, but the solution to inequality in sentencing is not to eliminate judicial discretion. If anything, it is to improve the conditions under which that discretion is exercised. Mandatory death does not actually solve it. It just moves it to an earlier point in the process, often allowing the matter to be more inconspicuous. Under a mandatory system, the real power sits with the public prosecutor. At Article 1453 of the Federal Constitution gives the Attorney General the authority to decide any criminal proceedings, what charges to bring, whether to reduce them, and whether to offer any arrangement. This discretion operates entirely outside the courtroom and beyond public scrutiny. This tension was in fact identified as far back as Tuan against the public prosecutor, where even Lord Diplock, who uphold mandatory death, acknowledged that mandatory sentences necessarily produce variation in moral blameworthiness among offenders who receive the identical sentence. He recognized the flaw over 40 years ago on the existing threshold being a rough legislative guess for accountability, not an accurate measure of it. True equality under the law requires that like cases be treated alike, different cases differently. A courier carrying drug unknowingly under duress is not morally equivalent to a syndicate leader. Giving them the same irreversible sentence is not equality, it is a failure of justice that Act 846 of 2023 has now addressed and corrected. The fourth argument is that the resentencing and abolition of mandatory death sentences puts dangerous people back on the streets. This misunderstands the Act 846, what it actually does. The alternative sentence under the Abolition of Mandatory Death Penalty Act 2023 is not a lenient one without measure. Under Section 34, which amends Section 302 of the Penal Code, for example, a person convicted for murder may now be sentenced to imprisonment of between 30 to 40 years, with mandatory whipping of not less than 12 strokes. This framework applies equally across all capital offenses, so it is groundless to assume abolition means release when it gives way towards proportionate sentencing within a serious and binding framework instead. The Magandern case further illustrates that courts are in fact applying Act 846 seriously, and Section 34 confirms that framework applies just as firmly to violent offenses. Just months ago, the accused was convicted of charges that would previously have carried a mandatory death sentence into a 30-year imprisonment plus 12 strokes under Act 846. The public is protected, the offender is incapacitated, and the judge was able to weigh the actual facts before arriving at a proportionate sentence. Most importantly, however, the deeper problem lies with the public safety argument, assuming that every person on death row is guilty, dangerous, and beyond rehabilitation. History contradicts this. Wrongful convictions in capital cases are a document reality in Malaysia and elsewhere, and an irreversible sentence cannot be undone. Article 5 of Malaysia's Federal Constitution provides that no person shall be deprived of life or personal liberty save in accordance with law. And as the federal court held in Li Kuan Hua against the public prosecutor, 2009, that constitutional right must be interpreted generously. It is only right where the consequence is permanent and irreversible. The law demands the utmost caution, and the case for abolition stands on every ground against it. I now hand over to the following member to outline the path forward.
The abolition of Malaysia's mandatory death penalty was the right decision. Constitutionally, it restores judicial discretion. Courts can now punish according to individual culpability, rather than imposing the same sentence on a coerced courier and a drug kingpin. On human rights, it ends the injustice of ignoring mitigating factors like a person's background or mental state. Upholding the right to life under Article 5 of the Federal Constitution, and empirically the deterrence argument fails. Donahue and Wolfer's 2005 study found no reliable evidence that the death penalty deters more than life imprisonment. Malaysia's own experience over 1,300 executions between 1992 and 2023 with no decline in drug trafficking confirms this, but we must go further. For concrete steps are vital. First, fully abolish the death penalty. 27 offenses still carry it as a possible sentence. Malaysia voted for the UN moratorium on executions in 2022. Now we must complete the journey. As Hood and Hoyle document, full abolition is the hallmark of a mature criminal justice system. Second, reconsider caning. The 2023 reform introduced whipping as an alternative to death, but Human Rights Watch and Amnesty International argue it amounts to torture or cruel, inhuman, and degrading punishment. A justice system committed to human dignity cannot retain corporal punishment while claiming to reform. Third, ensure fair resentencing for the 906 people still on death row. The federal court now has power to review these cases, but this process requires genuine access to legal representation, translation services where needed, and proper consideration of mitigating circumstances. Clear judicial sentencing guidelines must also be developed to ensure consistency across cases. Fourth, ratify the ICCPR. Formal ratification of the International Covenant on Civil and Political Rights would commit Malaysia to binding international standards, including Article 6's protections on the right to life. This would signal that our reforms are enduring, not cosmetic. So, was the abolition of the mandatory death penalty sound? Yes, it was necessary, just, and constitutionally grounded. It restores judicial discretion, upholds human dignity, and aligns Malaysia with global standards. But this reform is not the end. It is the beginning of a deeper conversation about the kind of justice system we want, one that punishes not out of vengeance, but out of a reasoned commitment to fairness, proportionality, and rehabilitation. Malaysia has chosen the right path. Now we must continue forward.